Our next case is SG versus JL, 18P 1289. Hold with for just a moment, please. Just for the record, I would note that the counsel for the appellant is present and prepared to argue. No brief has been filed on behalf of the appellee, and no one is present representing the appellee. When you're ready, you may proceed.
Thank you. Good morning, Your Honors, and may it please the Court. My name is Christina Paradiso, and I represent the plaintiff in the restraining order matter, to whom I will refer as S due to the impoundment of this case. Prior to June 2018, S went to the district court again and again and again and again and again and again, 6 times, to ask for protection from abuse. Both she and her children were in fear of the defendant. At each court appearance, there was a cost to both the plaintiff and her children, both in an emotional toll and in lost days of employment for S. At each of the appearances, the restraining order protecting S and the minor children was extended without modification. S met her burden of showing each time that the extension of the order was necessary to protect her and the children from the likelihood of further abuse by the defendant. However, in June 2018, S and her counsel appeared at the return date in front of the district court and asked that the restraining order be made permanent. In response to that request for a permanent order, the judge impermissibly cited his own personal philosophies regarding permanent orders and about parenting time.
Can I ask you a question first about the permanency of the order you requested? I understand, of course, that there is a certain cost, inconvenience, emotional or otherwise, to returning to court periodically. Other than that, is there anything about a permanent order that would have protected your clients in a way that a 2-year order would not?
As to the specific terms that were entered in this particular order, the extension for 2 years had the emotional toll and the financial toll, but all of the protections were not extended in June 2018.
I understand there was a modification as to the children, but as to the mother, let's say, was there any difference in the protection afforded by a 2-year order as to a permanent order?
In general, if I may, the protections in a 2-year order are not necessarily different than those in a permanent order. However, it is a matter of flipping the burden. And as we see in the McDonald versus Caruso case, the SJC decided that once we reach a certain quantum of evidence, a certain amount of proof, a certain need for protection, which I state that we have here in this case, then society has decided that the burden can and should be allocated to the defendant in cases such as this. And we no longer expect the plaintiff and the children, by extension, to appear time and time and time again to relitigate the case. Instead, as in the McDonald case, what should happen is that the burden of proof be allocated to the defendant to come back at some future point and show that circumstances have changed. And so it's not necessarily a matter of different protections, but a different burden of proof and a different expectation that would be set by a permanent order. After a hearing in which S's evidence was largely unrebutted, the district court denied S's request for a permanent restraining order here, extending it for only 2 years and vacating some provisions protecting the minor children.
Can I ask you, I know you're about to go there, but can I anyway lead off with a question about the change in the visitation? I know that there was reference made during argument before the judge to seeking an alteration or a modification of the visitation order in the Probate and Family Court. Was that ever done?
The defendant filed a complaint for modification but did not ultimately pursue that modification to obtain visitation with the minor children.
So the only judicial order with respect to visitation, well, there's no order other than the modification that exists in this case. Is that correct?
The 2012 divorce had certain provisions that would have allowed for visitation, but the defendant in this case did not ever avail himself of those visitation terms.
And has that been true since the modification as well?
That he has not availed himself of the potential visits? Yes, that is true.
And has there been contact of any kind since the modification of the order?
Other than that, not authorized? No. The district court checkerboarded the protections for the mother and the children in this case, continuing some, such as the requirement for the defendant to stay away from the children's home and schools, but not extending the provision that kept the children safe when they were anywhere other than those places. To the extent that the court heard the evidence and extended the order for 2 years, the court necessarily must have found an ongoing fear of the defendant and found that such fear was reasonable and found that orders were necessary to protect the plaintiff and her children. As testified and submitted documentary evidence to prove her fear and the need for the order. This evidence was unrebutted. There was no testimony by the defendant. There were no documents submitted by the defendant that would rebut any type of fear or show that anything, in fact, had changed.
Could I ask you about something you just said? It was unclear to me what happened with the provision prohibiting the defendant from going to the children's schools. There seems to be a discrepancy in the record about that. Could you clarify?
Yes, to the extent that I am able. There was some confusion about that because it appears that the judge, although he said that he was striking that provision, he then said the plaintiff's school. And it seems that that was an intent to cover the children's schools instead, as the plaintiff is an adult and not in school. Okay.
Was there ever any clarification of that?
No, there never was clarification of that. The judge was asked to reconsider the entire order in a 60B motion and denied that. The denial of that is not on appeal, but it does suggest the clarity of the resulting order.
Let me ask another question related to an earlier comment. You said that there was no evidence rebutting the fear of the children or the fear by the children of the defendant. There was at least an argument, as I recall, a representation made by counsel that the children enjoyed a good relationship with the father. Was there any evidence to support that offered at any time?
None that I'm aware, Your Honor. Instead, what was submitted was the testimony of the mother, of her observations of the children, and then also the documents from DCF regarding the abuse or neglect that had been perpetrated upon the children and the circumstances surrounding that neglect.
And the mother's representations at the hearing and in her affidavit about the children either terminating employment or not participating in school activities because they were fearful that the defendant might appear there. It struck me that those, I couldn't tell exactly when those happened. I thought that they may have been before the court earlier and that she was simply repeating something that had occurred earlier. Is that accurate?
No, Your Honor. Those incidents occurred since the entry of the 2017 order. So at the time that the court was taking this evidence, they would have been fresh since the last time the court had seen the parties.
I see.
So the confrontation at the Worcester Probate and Family Court between the defendant and the plaintiff occurred in June of 2017, and the parking outside of the child's place of employment occurred in July of 2017.
But with respect to the DCF records, those records are also conflicting. So couldn't the judge have refused to rely on them? Is there unreliable hearsay?
He could have, but the outcome of this case would suggest otherwise, in that he did extend the protections for the minor children, but not as thoroughly as he should have done, and certainly not by extending a permanent order. If he found them to be completely unreliable, we still had mother's testimony to fall back on, and also, the evidence of the inventory tracking reports suggesting that father still had rifles available to him, and the children had seen the prior incident where father had appeared in their front yard, and although he did not directly threaten them, he was brandishing one of the rifles. And so all of the testimony would have been enough, even had the judge not found the DCF records to be convincing.
We've looked pretty carefully at the order on the form where the judge ultimately modifies the custody provision and the visitation provision and the no contact provision with respect to the children. Beyond that order and his checking of boxes on that order, were there any findings or explanation made anywhere in the record regarding his rationale?
I do not believe there were any findings made directly. However, the judge's state of mind can be determined from his statements on the record. First, that he would not consider entering a permanent order, and second, that he had great concern as a father for the defendant's lack of visitation. I would point out to the court that his concern for the lack of visitation was misplaced, as any time a restraining order enters in a district court, the Probate and Family Court may always modify the terms of the restraining order in accordance with and to allow any visitation that the Probate and Family Court would subsequently enter. So the defendant would always have the opportunity to take the district court restraining order, bring it to the probate court, and have the probate court judge make a modification on the order that the terms would allow, with the exception of a supervised visitation perhaps, or seeing the children in a public place. However, that is not what happened here, as the defendant never pursued any available relief in the Probate and Family Court. The concern of the district court judge was outside of his scope and should not have been allowed to interfere with entry of full protection for the plaintiff and her children, as defendant would have had other avenues available to see the children had he so chosen.
On the request for the permanent order, the judge went on to say later that he has granted one in one case. So doesn't that indicate that he doesn't have a strict personal philosophy like you're arguing?
I believe that he says he's entered one in all of his years on the bench. And he did engage with, in a conversation regarding permanent. I'm not even sure what permanent is. And I don't think I've ever issued one. And
but then later he says, I've issued one permanent order in my 5 years.
Yes, but earlier, in a different point, and that is at the appendix, page 68, beginning around line 12, the court says, I don't think I've ever issued one. The trial attorney states, the court, I don't think I've ever issued one. I have a problem with entering a permanent order against on any type of case. What does that mean, permanent? Circumstances don't change? And the court may not make those types of statements on the records, on the record, no matter what the subsequent findings or order may be, it creates an impression of, at least an impression, of not taking all of the discretion available to the court and not making rulings in accordance with the law, but rather upon the judge's own philosophy and leanings.
Although the overall message, as I took it from those words, was that he was of the opinion that he didn't want to allow for the possibility that a permanent order would enter that would not contemplate the possibility of future changed circumstances, which is not crazy.
However, also not in line with the law, as if there would have been a permanent order, and then if there had been changed circumstances, as we see in the McDonald case, there is an avenue for relief from the prospective application of the order.
Thank you. I see your time is up.
Thank you.
Thank you very much for your argument.